Have you ever stopped to think about how a jumble of ones and zeros on a computer can literally become the smoking gun in a massive court case? Well, today, we're going to follow that journey, step by step, from the raw data all the way to the high-pressure environment of the witness box. But first, let's get one thing straight, because it's the most important rule of the game. All that incredible, painstaking technical work, all the digital sleuthing, it means absolutely nothing if you can't explain it in a way that makes sense. This one idea, right here, is the bedrock for everything else we're about to cover. So here's our roadmap. We're going to start with the foundation, which is the report itself. Then we'll talk about building your credibility. After that, it's all about preparing for the stand, what to do when you're actually testifying under pressure, and finally, we'll look at some key moments that happen outside the courtroom. Okay, let's dive in. Long before you ever dream of stepping into a courtroom, the most critical battle is actually fought right here, on paper. This is where the magic happens. It's all about translation, taking all that complex technical jargon, all those bits and bytes, and weaving them into a story that a regular person can follow and, more importantly, believe. Now, you should think of these less as friendly suggestions and more as rules for survival. Limiting your scope? That just means staying in your lane and answering only the question you were asked. Writing for your audience, that's the core of the translation job. And this last one, making sure your methods are repeatable, that is your ultimate shield because you can be sure someone is going to try and poke holes in your work. It's also really important to know the difference between these two documents. On the one hand, you have the preliminary report. This is the messy, behind-the-scenes stuff for the attorney's eyes only. It's considered high risk because it's full of notes and half-baked theories. But then you have the formal report. That's the polished, showtime document. It's structured, clean, and built to be presented as solid evidence. All right, so you've written a masterpiece of a report. But that report is totally worthless if the person who wrote it doesn't seem credible. So let's shift gears from the document itself to the expert who has to stand up and defend it. This part is all about building trust. And a huge piece of that is understanding your role. See, a fact witness can only state what they found. For example, the file was deleted at 10:05 p.m. Period. That's it. But an expert witness, they can take it a step further. They can say, the file was deleted at 10:05 p.m. and the techniques used suggest a deliberate attempt to hide that data. See the difference? That's the power of being the expert. So how do you earn the right to give that kind of opinion? You do it with this, your curriculum vitae, or CV. This is way more than just a resume. It's the detailed proof of your qualifications, your bona fides, as they say in the legal world. But here's a pro tip. Think of your CV as the script for your first performance in court, a performance we're about to get to. Okay, the report is solid and your credibility is established on paper. Now it's time to connect the dots between your technical world and the superstructured world of the legal process. This is all about getting ready for the main event. You can't just walk into a trial and start talking. There's a very specific flow to it, a rhythm. And as an expert, it's so important to know exactly where you fit in. Your big moment comes right there in the middle, during the main testimony phase. Understanding the context of the whole battle helps you prepare for your specific part in it. Before you can even get to your findings, you have to pass through a gate called voir dire. This is basically your official introduction to the court. And remember that CV we just talked about, the one that's your script? This is where it comes to life. The lawyer who hired you will walk you through your greatest hits, your education, your experience, your big cases, to prove to the judge and jury that you are, in fact, an expert. All right, deep breath. This is it, the main event. Everything you've done, all the analysis, all the writing, all the prep, it all leads to this single moment. Taking the stand and defending your work, usually while under a whole lot of pressure. Now, your testimony really happens in two completely different acts. First, there's direct examination. This is your home turf. The attorney on your side asks you questions you've probably rehearsed, letting you explain your report and your findings. But then comes cross-examination. This is where the opposing lawyer gets to come after you, and their only goal is to find cracks in your story. Which, of course, leads us to the million-dollar question for any expert witness, right? Because handling this pressure cooker situation is what truly separates the good experts from the great ones. It's not just about knowing your stuff. It's about how you carry yourself when you're under attack. You have to understand the traps that are being laid for you. The opposing attorney wants you to get argumentative. They're hoping you'll get defensive or start using a bunch of technical jargon that no one understands. They are literally poking you, trying to find a weak spot. So here's the secret. Your job is to be a teacher, not a fighter. Just stay calm, stay professional, and stick to the facts you laid out in your report. And finally, just when you thought it was all about what happens in that courtroom, right? It's important to know that a huge, huge part of an expert's job can actually happen in a totally different setting. And that setting is usually a deposition. So think of this like a pre-trial rehearsal. You're under oath, but you're usually just in a conference room with the lawyers and a court reporter. It's basically the other side's chance to find out exactly what you plan to say in court and to lock your story in place so you can't change it later. And this quote really brings everything full circle for us. It doesn't matter if you're in a quiet deposition or a packed courtroom. Your spoken words are the living, breathing defense of that document you wrote. It all comes back to the report. Every single thing in it has to be something you can stand behind and defend. Which leaves us with one final thought to chew on. At the end of the day, all that digital evidence, it's just data. It's meaningless noise without a story to give it context. The question is, in that courtroom, who is going to be the one to tell the most compelling, the most credible story? Because that's the person who wins.